I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeans Law Firm. Today we have Miss Jessica Mora. She is the Cromeans Law Firm Lien Specialist. She leads the firm's mechanics lien and collection department and is very passionate about her job and helping her clients, and enjoys taking on new challenges and thinking outside of the box to problem solve on behalf of all of her clients. So the subcontractors, suppliers, property owners, and other vendors will encounter all kinds of related questions, deadlines, paperwork when working on Texas construction jobs, and it's imperative you know about the lien process and how to get paid for what is rightfully yours. So today, Jessica will guide you through the time-sensitive process of filing a mechanics lien. And our main goal here at the Cromeans Law Firm is to teach others how you can protect yourself on the front end. I sent a handout earlier this morning and also last night. You can follow along with the presentation with that handout. It's all fill in the blank. And please note that we will have a Q&A portion at the end of the presentation. And this is your time to ask Jessica any and all questions you may have in regards to mechanics liens. I ask that you stay muted during the presentation, and once we start the Q&A portion, feel free to unmute yourself, ask Jessica questions directly, or you can send me any messages in the chat and I'll read those out as well. So without further ado, I will let Jessica take it away.
There we go. Good morning, everyone. How are you this morning? So I'm Jessica Mora. I've been with the Cromeans Law Firm for a little over 10 years now. I'm the office director and I'm the lien specialist and run the collections department. I love what I do. So Lee, let's start the slideshow. Okay, so why are liens so important? The construction industry revolves around credit. This is the reason why mechanics liens are so important. It's because you as a subcontractor or you as a supplier or even a general contractor, you are giving credit to the person in front of you, the person that hires you or your customer. You're not getting paid up front for what you're doing. So the mechanics lien is done so you can protect your interest and your money. So again, liens are the way to secure on a construction project. Liens are filed in the real property records. They're against the actual property owner, not the contractor, not the subcontractor, not the supplier. They're actually tied into the actual property itself. So because the owner may never have known or had a contract with the claimant, the law requires specific steps to have a valid lien. By following the specific steps, the owner will have to pay even if he doesn't have an agreement with you. If a claimant misses even one step of the sentence or a sentence that requires in the notice, the lien will become invalid. So again, it's all done on credit. The owner hires a general contractor. They don't know who their subcontractors are. They don't know who's supplying the material. That's why the notices are so important. Who can file a lien? Anyone who provides labor or material to the construction or repair of a house, building, or improvement to a property is entitled to a lien. There is different liens, guys. There is 4 different types. There's a homestead, there's a residential, there's a commercial, and there's public works. I'm saying that wrong. There's 3 liens and the public works is not a lien. We'll get into that a little later. What's a homestead? A homestead is a residence that is owned by an individual in the state of Texas. The state of Texas protects your homestead. So for example, the home you actually live in, that's my only property. I live there. That would be considered my homestead. So if you look at the little picture that we put in there, there's an address where it says mailing address. There's a property address. If you see the exemption part that's been highlighted, it says residential homestead. This protection means you cannot have a lien against the property unless there is a contract signed, notarized by the homeowner's husband and wife of married couple and filed in the real property records. For example, if an individual does not currently have a homestead and is building a new residence, which is intended to be their homestead, is considered their homestead even if they're not living in the home. Let me explain that. I'm renting a property, or I live in an apartment complex. I'm having my house built, my dream custom home. Even if I do not currently live at that property, that is intended to be my permanent home. Therefore, that would be considered my homestead. And because the state of Texas protects your homestead, we can't just file liens on homesteads. Okay, they can be invalid. There's a big penalty for doing so. For a subcontractor or a supplier to have a lien on that homestead, the general contractor who has a contract with the owners, that contract must be signed, notarized. If it's husband and wife, both of them must have signed that contract. It has to be notarized, and that contract has to be filed in the real property records where that property is located. If the home is in Montgomery, it has to be filed in Montgomery County. If the house is in Harris County, Harris County. Wherever the property is located, that contract must be filed for a sub or a supplier or anyone else to have a lien on that property. If there is not a contract filed of record, you do not have lien rights to that property. All right? Residential, homestead, residential, two different types of liens. Rental properties, investment home, vacation, rental properties owned by an entity do not fall under the homestead, but fall under residential. So a home owned by, if you look at the example here, the mailing address is one, but the property address is another. The exemption says none, which means the person that owned the homestead owns this property as well, but they can't have two homesteads. So this most likely is going to be a rental property, which falls under residential, which means I can lien this home even if there's not a contract filed of record. Okay? Timelines for residential jobs are very short. When I say timelines and it says months of activity, it does not matter when you invoice, guys. It matters when you did the work. So if I did work in January, if I am not paid by March 15th, my first notice to the owner, the general contractor, must be sent out. If I do not send that notice out the next month where my lien is to be filed, my lien will be invalid if I did not send that first notice out. So these are your deadlines. Again, it doesn't matter if you did the work at the beginning or the end of the month. They fall under the month's date, not when you invoice, when you did the work. Commercial jobs, spec houses, warehouse, shopping centers, private schools, etc. When I say spec houses, I'm talking about D.R. Horton, David Weekley, the big builders that have multi-homes that are flipping these houses. Those are considered commercial. Again, look at the example, the state class code in the CAD records. It says real property, commercial. Most commercial contractor projects are the following tiers. You have owner, general contractor, subcontractor, suppliers. Those are usually the way the tiers are. Because spec houses do flip so fast, we kind of like to tend to put those on a residential timeline just because you can be done with the job and it'll be sold in less than 90 days or 120 days later. So it's important to make sure if you're the last one on there to start your process for collections. That's only for spec houses. Commercial construction tiers, again, the owner, the prime contract is between the owner and the GC. So the owner will usually not know who the other tiers are on the job. The GC has a contract with the sub. So they won't know who the suppliers are. The subcontractors have an agreement with the GC. So they won't usually know who the owners are. The supplier agreements with the subs, so they don't usually know who your GC or the owners are. No one knows who anyone else is unless you've researched or asked your customers or ask the questions. So these are very important. You have to know this information to be able to start your collection process just in case. It's very simple to ask. I know a lot of us don't. I have a lot of clients who be like, well, they won't tell me. It's okay. We can research it a little bit. Timelines on non-residential projects. Again, spec houses, warehouses, commercial jobs in itself. It all goes off of month of activities again. But this one includes an extra notice. So the first notice for work done in January, first notice goes out actually only to the general contractor and the subcontractor if you're a supplier. And this notice is telling your general contractor, hey, I haven't been paid. I want you to pay me before I have to move forward and send my second notice to your owners and let them know. So you're giving them that opportunity. The second notice is April 15th. That notice does go to the owner, general contractor, subcontractor. The third month would be filing your lien by May 15th. Let me explain this a little bit more. I know nobody's done within a month of doing a job. You can start a job in January and not finish until June. Sorry. So let's say I did January, February, and I'm still working in March. That's okay. In that first notice, you can include January and February's invoices and the amount that you're due. And let's say I keep working and January, February, and March comes and my notice is due again in April. I can include all of those invoices in that one notice. So you don't have to constantly be sending notice every month. You just have to update the amount that you're owed. Your lien does not have to be filed. So if I finish working in April and I sent my second notice again in May, my lien doesn't have to be filed until June 15th because that's when I'm done. I hope I explained that pretty well. Public Works, this one is tricky.
I'm sorry, could you repeat what the last thing you just said again? About if you started, I'm sorry. If you started in...
So let's say I start my job in January, okay? And I finished in April.
Yes.
So you see how your first notice has to go out by March 15th? So you
Right.
have work that was done January and February. I've sent that notice out in March. I have to send it out in March, but I continue to work and I have January, February, March due. And my notice for January, I can send all of my invoices out for January, February, and March on April 15th.
Correct.
Because I have to cover my January and February timeline.
Right.
Okay. But because I finished in March, I don't have to file my lien until July 15th.
Because you finished in March, you don't have to file your lien until July 15th. Okay.
Yes. Because I've covered these 3 months
In the
with
notice.
this notice and this notice. So then I have until this time to file my lien.
Okay. So, okay. Thank you.
Hi, John.
Let me know. I can explain it again.
Hello, Jessica.
Hello.
Hi. So when you're explaining about the commercial stuff, is it 30 days or 60 days when you can first send your first notice to intent?
You can send your intent notice early. You just can't be late. So if I did my work in January and I want to start sending my notice in February, I can.
Okay.
I can go any month I want as long as it's not past these deadlines.
Gotcha. Okay.
Okay.
I have a question real quick.
Go ahead.
Okay, so when you did all your work in January and it comes time, you're still working on this job that's going to last until April. You do all your work in January, and then when it comes time that you need to give your final date to send out that 60-day mark, where you have to send out your notice for the invoices from January, correct? Everything that's owed from the work that's been done in January only, or can you include all the stuff that's been done in February on that same notice? I guess you
can
could, right?
include
'Cause it's 30
everything.
days.
You can include January and February and even March. If you're doing the March 15th notice, you can do January and February. If you're doing your April notice, you can do January, February, and March.
So if we were to send a notice on March 15th, we could include work that was done on March 14th.
Yes,
Okay, so, and then so that's where, so as long as we're covered for the very first initial January, right? Okay,
correct.
okay, thank you.
I have one last question. And since because you said, say we finish in April, or I'm sorry, in March. Oh, wait, I'm sorry. You were saying something about we can, because if we already noticed an amount, the lien, like let's say January, and it's past May now, I can still lien until the job is complete? I'm sorry. Did that make
You
sense? I don't know if that makes sense.
you can lien early. You just can't lien late. So for example, you gave them notice for the month, let's say you gave them notice in March 15th.
Right,
And like the gentleman said, he was owed January, February, and March 14th.
right.
You noticed that March 15th. You
Yes,
sent the owner notice April 15th.
correct.
If you want, you can file your lien by May 15th, or you can wait until July 15th. You can lien it early, you just can't lien it late.
So one more
Wait.
question about that. So when you do file the lien, it's only for the month of January though, correct? Not,
We're liening for everything.
oh, okay, okay.
Okay, I guess what I was asking was, okay, because you said you can lien early, May 15th, just not late, July 15th. So I guess what I'm asking is, does the lien date get pushed? I feel as though it's getting pushed back if you're keep noticing.
Yes. If you keep working and you keep noticing, your lien gets pushed back, your lien date.
So I don't necessarily I wouldn't have to necessarily lien May 15th for January as long as I'm including it in the notices that continue until the work is complete.
Correct.
Okay, perfect. That's what I wanted to know. Thank you.
You're welcome. Okay, public works, police stations, fire stations, schools, anything that's owned by the county or the city, you don't have lien rights to. You cannot lien these jobs. Because they're owned by them, they're exempt from liens, but they have what's called a payment bond. So if you look at this example, it says other exempt government. Guys, all you have to do is look at the county records and it's going to pop these addresses up if you look at them and research it, and it's going to tell you whether it's exempt or it's a residence or it's a commercial job. I don't know how many of you know about payment bonds. The GC is required to have a payment bond on public works jobs. You have to file a claim with the insurance company if you're owed money on a public works job. You cannot lien these jobs. These jobs are exempt from liens. There is a timeline for the public works. Can we get there? There we go. Timelines for public works. These are shorter because we can't lien for these. If you look at it, the first one is the notice to the original contractor by the subcontractor or the claimant. Your second notice is to the surety. Notice to the owner, general contractor, subcontractor. This notice, it's not just a regular notice. This notice has to have a sworn statement, meaning I am swearing to the amount that I'm owed. I'm swearing that I did this work. So it's important to have this information in the front end. I can tell you right now, getting a payment bond is not an easy task. I've had clients that call me at the last minute and I am going crazy to try to find a payment bond because the general contractor does not like to give us that information. Why? Because when you have a payment bond, you are personally guaranteeing that bond. And if that insurance company pays out your claim, they're going to go after them for it. So they fight tooth and nail to give me that information. It is public records, however, but it's not filed anywhere, which means we have to call the county or the fire department. I mean, anybody and everybody to get a copy of this payment bond. They have up to 10 days to give us that information. So if you are doing public works, please request a copy of their payment bond at the beginning of the job, when you start working. If not, you need to ask for that as soon as possible and try to get a copy of it. The collection process, GC usually have if you're the GC, you have what's called a constitutional lien. When I say GC, I mean the prime contractor. You can have a contract with the owner that you're remodeling a house. You can have a contract with the owner for remodel or building a warehouse. You have what's called a constitutional lien. A constitutional lien, the lien writes, because you have a direct contract with the owner of the property, you don't have to send any notices. You have the right to place a lien on the property at any time, as long as they continue to own the property. Subcontractors, you will have to follow the statutory guidelines. So if I have a contract with, I don't know, anybody, and I'm doing a build out for an office space, if I had the contract directly with that owner, as long as they own it 3 years down the line and I'm still trying to collect my money, I can file a lien. As long as they continue to be the owners, I do not have to send notices. I can just file my lien. I usually recommend our clients have what's called a job info sheet, which I love, by the way, just FYI. The job info sheet I like to have, this is usually, it should have the project name, the exact address, the GC's information, and owner's info if you have it. This is a quick tool when you have collection issues. Verify information provided. Like I said, the county appraisal districts will provide you with some information for the owners. The website, this is Harris County. Montgomery County has it. Bexar County has it. Everybody has an appraisal district. It's a very easy tool to use. You can literally Google the address, Google the zip code, Google what county it's in, and it's going to tell you what county that property is located in. Go into the website, look for the address, and it's giving you some type of owner information. An address, it doesn't give you a phone number, it gives you an address. So that's an important tool to begin your research and your collection process. Again, the main information that's going to be on that county website is going to be whether it's residential, commercial, or public works. You might want to know that in the front end so you know when your timelines are going to hit and make sure you stay on top of those. Verifying the GC. A lot of my clients that I've had never ever call the office. They always have the project manager's phone number or the superintendent. It's okay to call the office to verify their information. So Google it, or the Secretary of State, or the Texas Comptroller. If you put their information in there, it's going to give you their mailing address. The mailing address is very important because if you have to send your notices out, you already have that in hand. This is the Texas Comptroller website. Again, once you have the information, you're ready to release your material collection notices. Notices start when the debt incurred, when the material supplied, and when work was performed, not when you finish the job. Again, that is your time starts when you start being owed money. If I did work in January and I'm owed in February, my January timelines have already started kicking in. Examples on residential labor and material supplied in January. The first notice of intent to lien notice sent to the owner of the GC and the customer must be sent by March 15th via certified mail return receipt. Remember to include your invoices or accounting statement. FYI, if you do not include an invoice or your accounting statement, your notice is no good. It does not matter if you supplied at the beginning or the end of the month, it all falls under the same timeline. If you miss the intent notice or sent to the wrong address for any reason, do not file your lien, it will be invalid. There is a $10,000 penalty for filing an invalid lien. Lien filing, filed of record by April 15th in the real property records where the project is located. The lien should include the following information: owners, GC, and customer information, who your agreement is with, a legal description, when and what type of work you did, date the notice was sent out. Notice, you see how it says the date notice was sent out? If you did not send out that intent notice, your lien is invalid. Do not file that lien. A copy of the lien must be sent to the owner's GC customer within the 5th day of filing. 5th day of filing, you can send them a copy of the lien being filed. You don't have to wait till the original to be returned to your office. So if I'm going to file a lien, I don't have to wait to get that one back. I just mail them a copy of the lien that I'm filing within 5 days. So if I file it today, I have 5 days from today to give them that notice. It doesn't matter. You have to send them notice even if it's not the file stamp copy. Please send your notices out certified mail return receipt. Example on commercial. Notice to the general contractor must be sent by March 15th. Remember, include your invoices or accounting statements. Again, it does not matter when you did the work. They fall under the same timeline. Second notice goes to the owner, general contractor by April 15th. Certified mail return receipt. Again, make sure you include your accounting statement or your invoices. If you miss any of those notices or sent it to the wrong GC, your lien will be invalid. There's a $10,000 penalty, again, for filing an invalid lien. Same thing, filed of record in the county where the property is located by May 15th. The lien has to include the owner, the GC, and your customer information, who your agreement was with, the legal description, when and what type of work you did, date notice was sent out. Again, copy of the lien must be sent to the owner, the general contractor, and the customer within 5 days of filing. Public Works, again, this is different. Your first notice to the general contractor and the customer must be sent out by March 15th. The second notice is a bond claim. The notice is sent to the owner, the GC, the insurance company, and the customer by April 15th, certified mail. This notice includes that affidavit of sworn statement along with a copy of the payment bond and your invoices. So if you see this little example that we have here for certified mail, I'm going to tell you that this is very, very important. I know it's the dinosaur age. I know that it's a pain, but this must be done. I don't know how many times we have had to prove up our liens. And when I say prove it up, they want to make sure that we mailed it out on time. Those notices were mailed out. This little receipt has done miracles for that because it will show you, I'm not sure, do we have a next slide? Sorry. So I guess it's not in there. The receipt, if we take this receipt to the post office, they're going to stamp it with the date that it was actually mailed out. So we keep those as evidence that we mailed it out on time. That is very, very important. Certified mail return receipt, because you're going to get a green card back as to who signed for your notice. Now, I can mail out notices left and right, but if they don't pick it up, that's not my problem. Your burden is just to prove that you mailed it out on time. It's their responsibility to pick up your mail, not yours. So we're going to go a little bit into waivers. The state of Texas has provided 4 statutory waivers that should be used. They include the conditional on progress, conditional on final payment, unconditional on progress, unconditional on final payment. Unconditional on progress. This waiver can be signed in exchange for a check, payment that has been received, or is being mailed. This waiver also means that you still are working or payment is pending. So please, if you are still working on the job and, hey, I'm going to mail you this check, perfect, mail it to me. I want an unconditional. Nope. I'm still working on the job. I haven't gotten that check. That check hasn't cleared. I'm going to give you a conditional on progress, which means I haven't received the payment, but I'm still working. Conditional on final means this is going to be my last check. I haven't received my last check. I haven't received my retainage. So I'm giving you a conditional on my final payment. An unconditional on progress. I'm still working on the job. I've received a check. That check has cleared, but it's telling them I've got the check, it's cleared, but I'm still working. So I'm not paid in full yet. Unconditional on final payment. This one is I have been paid everything, including my retainage. I'm owed nothing. I am completely releasing you of all lien rights that I may have. Please, if you have not been paid in full, do not sign this. I don't know how many times I've told clients that when they bring this in, oh, I signed it because they were mailing it. They made me sign it. It clearly states, do not sign this if you have not been paid. They cannot force you to sign an unconditional if you have not been paid. If you sign this unconditional on final, you have no lien rights. Breakdown of retainage. Retainage is my favorite subject. By enforcing retainage, you can learn to protect yourself, your money, time, and resources in your construction project. A retainage allows the client to pay only a portion of the full payment for a project and withhold the rest until the project is complete. Retainage is usually not supposed to be between the subs and the GCs. Retainage is a standard practice within the construction project and is required by nearly all construction loans. It is a 10% of the contract amount between the owner and the original contractor on any project. Although the legal definition of retainage says nothing about subcontractors, most original contractors take 10% from the amount due to the subcontractor throughout the project. Every contractor has an owner hired directly every contractor hired directly by the owner is the original contractor. If an owner hires all the trades directly, each contract is its own original contract. This is important because all lien claimants can be limited to only 10% of the contract where they were supplying labor or material. Here's what that means, is if that owner that had the contract with the general contractor withheld 10% of their contract, and we have 20 lien claimants that has not been paid and have filed liens, and all those liens are good, we're only limited to that 10%. But from experience, those 10 lien claimants, more than half of them will be invalid. So then it opens it up to more. If that owner did not withhold the 10%, they are responsible for paying everyone's liens as long as they're valid. Why retainage is important? Again, it's withheld. Retainage is essential because it can limit the owners to liability, like I just explained. The property owner withholds the 10%. The time frame for filing a lien can be shortened if the project is complete. This is another topic. If the project is complete and there is an affidavit of final completion is filed with the county clerk, the owner withholds the 10%. At that point, everybody that worked on that job only has 30 days from that affidavit to file a lien. It does not matter if you came in a day before that affidavit of final completion was filed. Normally, a lien claimant has until the 15th day of the 4th month to file a lien. After the material is supplied to file a lien, the time frame can be shortened to 30 days after final completion if the owner follows the steps. Retainage generally does not become due to the subcontractor until 30 days after final completion, and when the general contractor receives the retainage payment. This ensures the subcontractor will have a valid lien on retainage, and they should file their liens at the completion of the project. So if I did my work, and again, I waited, I did my notices, I sent out my lien on time, and I'm still owed retainage, then I should include retainage in my lien. I got paid all my invoices, for example. I'm not owed any money. I'm just owed my retainage. You should still lien for your retainage when you're done, because that project can go on for a year and you've been done and then you forget, or they're not going to pay you until they don't have to pay you until 30 days after they've been paid their retainage. I've had multiple clients who don't file and they're 2 years down the road and they're like, well, I know they got paid retainage. It's been over for over a year, but they didn't file that lien. So now they have to file suit to get that money because they don't have any more lien rights. So I hope you guys got some good information. Please ask me questions. I know it would be a bit confusing.
Thank you, Jessica. Really appreciate it. So right now we're going to open up the floor for any and all questions you may have. Please feel free to unmute yourself or send any questions in the chat, and I'll read them out to Jessica.
I have a question about, is there anything you can do for a truck driver and you don't get paid? This does not apply to truck drivers, does it? I don't think it does.
No, it does
Okay.
not.
Yeah, you gotta actually do something, improvements to qualify as a lien claimant, right?
No, a lien, because you're a truck driver, so you're not really doing anything on real property to
Right,
be able to file a lien on.
right, okay,
So technically, no.
okay. Is there any statute,
Go ahead, I'm sorry.
is there any statute that truck drivers can use to get paid for jobs they've done that haven't been paid for? That you're aware of?
A breach of contract is 4 years.
Okay, so just a breach of contract claim is pretty much it.
That's pretty
Okay.
much.
Okay, thanks.
No problem.
I had a question regarding retainages.
Uh-huh.
I was listening, there was a lot of if the owner did this, if the owner did that, or if this and this, then this and that. That was a lot. So just more simplify, like just to protect. I know in particular for us, retainages is where, you know, when it gets to the retainages, I'm new to this company, so I have, they don't necessarily move forward with retainages, but like to best protect, would you say once we are complete and we are owed retainage, and do notices get filed for retainages, or does it go straight to lien? Or
So-
I'm just trying to understand better how to best protect for the retainages.
So here's what I've learned about retainage. It's very complicated. I'm sorry. And what is best? What type of work do you guys do? Let me understand what you do. Do
We're
you come in?
typically subcontractor, and I heard you say that subcontractors don't usually, or GC shouldn't withhold retainages, but some of them do, sometimes they don't. And we're typically the subcontractor for
You coming in at the
90% of our
beginning of the
jobs.
job or the end of the job? Sorry.
I'm sorry?
Are you coming in at the beginning of the job or the end of the job?
No, we usually come in at the beginning.
Okay, so your best bet, to be honest, is once you're done and the last invoice that's owed is for retainage, go ahead and start sending out your notices for that. What they're going to say is, oh, it's not due yet.
Right. Typically the response is we haven't been funded. I'm sorry, did you hear me?
Yeah, the response is what? I'm sorry.
Typically the response is they haven't been funded for retainage yet.
Exactly. And that's
Right.
what they're going to say is we haven't been funded, so it's not due yet. What your response to them is, of course it's not. I know it's not. But to protect my retainage, I have to go ahead and send out this notice and file my lien for that.
Right. Okay, perfect. That's what I wanted to know. Thank you.
Mhm. You're welcome. I have a fly. Yes, I think that's, what was this? I'm sorry, y'all. I have this fly that's bothering me.
I was wondering what was going on. So we do have a question that was just sent in the chat. Two things. I will be sending a follow-up email to everyone. Just it'll have the full presentation, and then tomorrow we'll be posting the actual webinar video. I did a recording today, so we'll also send that out on our Facebook page and on our YouTube channel. But we did get a question from Kiara. Should you bill retainage at the completion of your portion of the work or wait until the project is completed altogether? Some contractors they've worked with or worked for as a sub direct us, in quotes, when to bill retainage.
They will always tell you when to bill your retainage. You guys have pay applications, right? So the pay applications will usually read what your original contract is, and then it says how much you're owed for that pay application, and then it says how much the retainage is for that pay application, and then it tells you what payment you're requesting. Okay, so you're automatically on those pay applications, it's already showing that you're owed this retainage. So you have that amount at your final pay app. Yeah, they don't want you to bill them for retainage until they're done. But you got to remember, they're not protecting you. So do I recommend you go ahead and send out your invoice? We tell all our clients that. Send out your final invoice. There's nothing wrong with that. You're protecting yourselves. And technically on your pay applications, it's already included in there. So you're kind of already billing it. Did I answer that good? Sorry.
I have a question to continue on to that. What would you say then for like there's certain contractors that will direct us to use a kiosk for their pay apps, right? And then when it gets to the retainage, it's closed.
Oh yeah, I've seen that one before. They don't even let them submit their invoice.
What would you recommend we say or do, you know, because their work we can't bill?
Yes, you can. You can mail it. You can
Okay.
mail it and you can email it. If
Okay.
you mail it to them certified mail. You have proof that you've mailed that invoice.
Okay. Okay. So you just said that we can also email. So then I kind of want to backtrack a little bit for the same thing, the kiosk. I've had them, you know, again, like I said, I'm new to my company. So coming in, there's been times where they're like, oh, invoice, and I email, because that's how I invoice most of our jobs. And then they'll come back and say, oh no, you have to send through the kiosk, it's rejected. And like, and this is like 3 months after down the line where I'm asking them to advise for payment, and they're like, oh, it wasn't accepted because you didn't send through the kiosk. But I did email. So is the email valid?
It is, but I will be honest, I prefer you mailing it because now you can say somebody in your office received it.
Right. Okay.
You've mailed it, you've sent it to them, you have proof that you have, you're fine. I don't know how many times they do. I don't know why they do that to all subs. They literally just erase them from the system so they can't invoice them.
So would a read receipt
That would
hold
be good too.
that they opened and read it?
Yeah, you can use that.
Okay. Because I'm assuming if you're mailing, then you would say mail every invoice with like a certified. How would,
You want, when you're mailing stuff, you do want certified. And it's just easier when we're in, honestly, when you're moving into litigation,
right.
being certified mail, they can't say, oh, you never
You-
sent it.
Right. Okay. Okay. That was my question. Thank you.
I have a question about the commercial timetable of the notices.
Okay.
The first notice, I guess have not been using a first notice. We go straight to the second notice and notify the intent to lien to the owner. Can you explain what the first notice is and the difference in the first and the second?
So the first notice goes to the general contractor. Now, here's a little trick that I've learned. If you are in direct contract with the general contractor and not a sub of a sub, you can kind of not send that first notice and get away with it because the general contractor is aware of the debt to you. Okay? Because you've submitted your pay application or your invoice. So they know that you have a debt, that you're owed money, and you can go into that second notice. But if you are a sub of a sub or a supplier, you cannot skip that first notice. That is letting the general contractor, hey, I was hired by a sub of yours, I was hired by, or I supplied to a sub of yours, and I'm owed money from them. You're giving that general contractor the opportunity to withhold the money that he's going to be paying that sub to make sure you're covered.
Okay, well, if we are the subcontractor and we do not use a first notice, does that jeopardize our lien rights in any way?
No, you're okay. You should be okay if you have the contract, if your agreement is with the general contractor, because they know that you're owed money.
Okay.
Do you have any other questions for Jessica?
One more question, and it may have been answered. I'm sorry, I joined midway. Your timetable again for filing the lien is 30 days after the second notice,
Mm-hmm.
but you're continuing to do work and you have ongoing outstanding invoices. By updating each month the outstanding balance, does that push the lien filing out 30 days
Yes,
past the final?
yes. So if you continue to do work to the last month that you did the work, you have until that deadline to file your lien. It's pushing back your lien date deadline until you're done, as long as you continue to send your notices out.
Okay, so 30 days after the final notice is the true deadline.
Yes.
Okay.
I have a question regarding residential work. If a owner have you do work, but then and it's homestead, but they use it for office use. It's for office. Their checks that they pay me is under a company. Would that still be considered a homestead for someone?
Is the property owned individually or by the company?
Individually, but the company is, I guess, within the house, they're using it. What I'm doing for them supposedly is for office use. It's separate from the house. We did an addition.
So they can argue the homestead, and we're
Yeah.
going to argue that it's not.
Okay.
It's best to have a contract on that, just because it can get very tricky.
All the checks are under the company's name, but the contract, I want to say, was signed by the owner and not the company name.
Was it signed by
Although
both?
my estimate is actually under the company that it's, that he's with, and then he signs underneath that he approves the job. But it's his house.
That can fall under a homestead.
So I can't do anything.
We can, I would have to look at your agreements,
Okay.
to look at it and kind of do a little bit of research and figure out what we can do.
Okay.
Any other questions?
All right. Well, we really appreciate your time, Jessica, and everyone that's joined us today. If you do have any questions further for Jessica, I'm going to be sending out again an email with her contact information. It'll have the full presentation. So please feel free to reach out to Jessica with any and all questions you may have following this webinar. We really appreciate your time today. We know everyone's very busy. We're kicking off the new year, and we just hope everyone stays safe and healthy, and we hope to see you very soon. Thank you all.
Thank you.
Thank you.